When performing what I thought was routine legal research as a normal part of my practice, I came across a reference to trusts holding property in joint tenancy with another party, and the legal support being in the California Civil Code of all places. This sent me down a bit of a rabbit hole because the prospect of this was strange to me. Hi, I'm Andrew Bethel, and before going into what I was able to find, I need to quickly give some context as to why this kind of made me raise an eyebrow when I first came across it. We have done a video on joint tenancy versus tenants in common in the past, but the short explanation for joint tenancy is that it is co-ownership of property between two or more parties with the right of survivorship and requires some unities when creating that joint tenancy. First, the holders need to have acquired their interest at the same time. Second, they need to have the same interest, as in 50-50 if two parties or 1/3 each if three. Third, the parties need to each have access to the whole of the property rather than sectioning off, sections. Fourth, the parties need to have acquired their interest from the same source. And finally, a right of survivorship means that upon the death of a co-owner, their interest terminates automatically and the property is held outright by the surviving co-owner or co-owners. The important aspect is the right of survivorship, as it's the primary difference between a joint tenancy and a tenants in common, where the deceased person's interest stays in their estate at death. Due to this, it stands to reason that a trust would not be allowed to be a joint tenant on a property with another, since the trust is a legal entity that won't die but only terminate after the conditions have been met, usually the distribution of the trust property held inside the trust. This means that even if we consider the trust's death to be its termination, the trust can only terminate after it transfers out its interest, meaning the joint tenancy is broken since the trust no longer owns the property. All of this ended up bringing me to California Civil Code section 683A of all places. And the Civil Code does have rules regarding holding title to property, but one would expect rules regarding trusts holding title to property to be in the code sections governing trusts in California, that being our probate code. Regardless, the relevant provisions of section 683A, after removing the extra fluff and leaving only the relevant wording, we have, and I quote, "A joint interest is one owned by two or more persons in equal shares by title created by a single transfer when expressly declared in the transfer to be a joint tenancy or when granted to trustees as joint tenants." What this seems to imply is that, yes, a trust can hold title with another party as joint tenants. Trusts title being vested in the trustee since they are the person who manages the trust assets. However, the code is silent on how this affects the right of survivorship that accompanies joint tenancy. Even if we consider the death of a co-owner to be the death of the trustee of the trust, this wouldn't fit, as 1, the trustee is not the owner, only the manager. 2, the trust owns the property, which, as I mentioned, cannot die. And 3, if the trustee were to die, either the trust will have a provision on who succeeds the prior trustee, the beneficiaries can elect a new trustee, or a court would end up appointing a new trustee. The trustee dying doesn't mean the trust then loses its assets. It will continue on and have guidance on what to do next. So to come back to the question at hand, yes, it appears a trust can hold title to property with another as a joint tenant, but it's something I would highly recommend against doing unless there's some specific strong legal support for it, something I've yet to really come across. It's an interesting legal implication from a theoretical point of view, but shouldn't really go beyond that. The way our office interprets the matter, it appears to be more of a one-way street, in that if a trust holds property in joint tenancy with an individual, When that individual dies, their interest goes to the trust, but there will not be a case where the trust interest goes to that individual. A trust can hold title to assets with third parties, but the entire purpose of a trust is to designate who controls the trust assets, how those assets are safeguarded, and where they should go after the settlor, the one who made the trust, passes away. To risk losing a trust asset because of a niche way of holding title is frankly plain silly. If you find yourself in a situation where your trust is going to hold title to property with a third party, you should have an estate planning lawyer involved to ensure title accurately reflects your intent and doesn't violate the trust provisions themselves. Thank you for watching. If you enjoyed the video, be sure to check out some of our other excellent videos here, but don't forget, hit the like button, subscribe, ring the bell, and tell us what you'd like for us to cover down in the comments below.